Probate bonds. Why do you need them and how much do they cost? Let's start with the cost of the bond. Probate bonds costs vary depending on the amount of coverage needed and also depending on the size of the estate. The amount is typically based on the total of the estate's value that the fiduciary may be responsible for. Reasonable costs depend on who the insurer is and the bond amount. Bond companies in California generally charge probate bonds within the range of 0.5% and 0.8% of the total bond amount needed. For instance, for an estate valued at $500,000, the probate bond premium might range from $2,500 to $4,000 to secure. In contrast, the bond fee for a larger, say $1.5 million estate could be approximately $7,500 or higher for the premium rate. When determining the probate bond cost, bond companies look into different factors of the applicant, such as credit score, considerations for obtaining a bond, personal property for collateral, and the applicant's occupation. The fee that is charged for the bond is non-refundable, although the petitioner or the administrator will eventually be reimbursed by the estate. The purpose of the probate bond is designed to protect the estate and the beneficiaries in the event that the executor fails to live up to his duties and obligations. When applying for a probate bond, court documents from the clients are required. The bond can give the estate's beneficiaries peace of mind, reassuring them that even if the executor somehow loses or worse, makes off with the estate assets, they will be compensated. Sometimes the will itself will require the executor to post a bond. The probate court may also order the executor to post the bond, even though the will waives it. That is often the case when the petitioner lives out of state. If neither of these circumstances apply, the estate may not need a bond at all. The other heirs can also sign a waiver that they do not require the administrator or executor to get a bond. The law holds an executor to a high standard of behavior. Executors have a fiduciary duty to the beneficiaries of the deceased estate. A fiduciary must act in the estate's best interest, not in their own. In short, the fiduciary must perform in an ethical and legal manner.